Hello everyone, welcome to EduTap and welcome to the series that we have started exclusively for the upcoming UPSC EPFO exam 2025, wherein we'll be doing 15 MCQs in a session, as part of which we'll be doing today in this session Labor Laws Payment of Bonus Act 1965 Part 2. We have already done Part 1 of this. Now, why is this series important? See, be it UPSC EPFO APFC exam or the AO or EO exam, labor laws and industrial relations are considered as one of the most important topics because close to 15 plus questions out of 120 are asked from these topics, which is actually a very good number. And given your preparation, even आप basic भी अच्छे तरीके से करोगे इसका, basic concepts और basic acts etc. and उनका जो भी रिलेटेड कॉन्सेप्ट्स एक्सेट्रा वो भी करोगे तो वेरी इजीली आप 10 प्लस क्वेश्चंस तो आराम से सॉल्व कर सकते हो, विच इज एक्चुअली हाई स्कोरिंग. सो पोटेंशियल भी अच्छा है, वेटेज भी अच्छा है एंड टॉपिक्स तो इम्पॉर्टेंट है ही. सो इफ यू रियली वांट टू स्कोर हाई in any or both of these examination, I would suggest you to watch these sessions regularly. Moreover, we are expecting the UPSC EPFO 2025 notification very soon. So given the context, notification भी आने वाला है and उसमें ये सारे important भी है, तो definitely I suggest you to go through these sessions regularly so that आपका जो practice है, revision है, वो भी हो जाए, practice of questions है वो भी हो जाए, because we are doing all these acts in the form of MCQs. Moving on to our first question of this session. Which of the following conditions are considered when computing the number of working days for an employee under section 14? Why number of working days किस लिए important है? बोनस पे करने के लिए, राइट? बेस्ड ऑन द नंबर ऑफ वर्किंग डेज उसके बेसिस पे ही वो कैलकुलेशन होगा. ओके, सो हियर इफ the employee has been laid off during the accounting year, even then वो working days में ही compute करेंगे हम लोग, तो definitely this is true. The employee has been on leave with salary or wage during the accounting year, though the person is on leave but still वो leave उनका accrued हो गया, जो भी होगा, इसीलिए तो wage और सब कुछ pay हो रहा है. In that case definitely that will be included. अगर wage pay नहीं हो रहा है then that will not be included. Okay, the employee has been absent due to temporary disablement caused by an accident arising out of and in the course of employment. Definitely ऐसे चीज में भी, because वहाँ पे भी उस टाइम पे मेडिकल लीव टाइप का होगा, so definitely वो भी इसमें काउंट करेंगे हम लोग, number of working days even in their absence. The employee has been on maternity leave with salary or wage during the accounting year. Definitely that person will also be considered, that is the days in leave also as working days. So all of these above are correct when it comes to the computation of number of working days for these people. So here the correct answer is C. So moving on to our next question. Which of the following statements are correct, is or are correct regarding the set on and set off of allocable surplus under section 50? Now, if the allocable surplus exceeds the maximum bonus payable in any accounting year, the excess shall be carried forward and set on in the succeeding accounting years up to a maximum of 4 years for payment of bonus. ओके, सो इस साल में अगर एलिकेबल सरप्लस बहुत ज़्यादा, मतलब मैक्सिमम बोनस पे करने के बाद भी बच रहा है, दैट वुड बी कैरिड फॉरवर्ड टू नेक्स्ट ईयर. एटलीस्ट 4 years तक उस अमाउंट को हम लोग बोनस के लिए यूज कर सकते हैं. सो दिस इज वेरी मच ट्रू. If there is no available surplus on the allocable surplus falls short of the minimum bonus payable, वो भी कम पड़ रहा है, in that case there is no sufficient amount that can be carried forward for set off. This deficiency shall be carried forward to be set off in the succeeding accounting years again up to 4 years. Okay, फिर उसको set off करते जाएंगे, तो loss की तरह ही है, तो that would be set off in the following years. सेट ऑन जब होगा जब एक्सेस होगा, सेट ऑफ जब होगा जब कम होगा. ठीक है, yes, this is also true. In calculating the bonus for a succeeding accounting year, any amount carried forward for set on or set off from the latest accounting year shall be prioritized. नो, जो अर्लियर अकाउंटिंग ईयर है उसका प्रायोरिटाइज होगा. जब नेक्स्ट स्टेटमेंट पढ़ेंगे ना तब हमें ये समझ में आएगा. द अमाउंट ऑफ सेट ऑन और सेट ऑफ कैरिड फॉरवर्ड फ्रॉम द अर्लीस्ट अकाउंटिंग ईयर shall be considered first when calculating the bonus for the succeeding accounting year. नेक्स्ट ईयर का जब करेंगे तो अर्लियर ईयर का हम लोग कंसिडर करेंगे. सो हियर इन दिस केस दिस इज फॉल्स एंड दिस इज बिल्कुल कॉन्ट्रडिक्टरी है दोनों में. सो ईदर वन शुड बी करेक्ट, राइट? सो हियर फोर्थ इज द करेक्ट. सो 1, 2 and 4 आर द करेक्ट स्टेटमेंट्स इन दिस. सो हियर बी इज द करेक्ट आंसर व्हेन इट कम्स टू section 15 of the payment of bonus act. So moving on to our next question. Which of the following statements is or are correct regarding the special provisions for newly set up establishments under section 16? Section 16 में कुछ special provisions है with respect to certain establishments, that is actually newly set up establishments. So for the first 5 accounting years, the bonus is payable only for the assessment years in which the employer derives profit, and the provisions of set on and set off do not apply here. क्योंकि वो तो स्टार्टिंग में ही है, सो एक बेनिफिट है. सो यस, दिस इज वेरी मच ट्रू. In the 6th accounting year, set on or set off is done by considering the excess or deficiency of the allocable surplus for the 5th and 6th accounting years, and this is very much true. Okay. In the 7th accounting year, set on or set off is done by considering the excess or deficiency of the allocable surplus for the 5th, 6th, 7th accounting years. As you can see here, 5th year के बाद 5 years के बाद वो धीरे 1 year on year 1 year add कर रहे हैं, right? set on and set off का करने के लिए. क्यों? By 8th year once they reach, वो 4 years वाला जो clause है ना वो applicable हो जाएगा. See. So this is also true. From the 8th accounting year onwards, the provisions set on and set off apply in the same manner as they do for other establishments. That is 4 years तक वो carry forward कर सकते हैं. So in this case, all of these statements are true. Hence D is the correct answer. Moving on to our next question. If an employer has already paid a customary bonus such as पूजा bonus etc. जैसे कि join हो रहे तो उसमें कुछ customary bonus कभी कभी मिल जाता है to an employee in a given accounting year. The employer is required to pay the full amount of bonus payable under the Payment of Bonus Act without adjusting the customary bonus paid earlier. Now you have to tell me whether this statement is true or false. Now this falls under section 17, adjustment of customary or interim bonus against the bonus payable. So here in this case, अगर कुछ कस्टमरी या पूजा बोनस जिसको बोलते हैं या इंटरिम बोनस अगर कभी पे किया है एम्प्लॉय को एम्प्लॉयर ने, तो डेफिनेटली द एम्प्लॉयर वो उसको एडजस्ट कर सकते हैं. सो दिस स्टेटमेंट इटसेल्फ इज फॉल्स बिकॉज एम्प्लॉयर इज एंटाइटल्ड टू डिडक्ट द कस्टमरी बोनस पेड अर्लियर फ्रॉम द बोनस पेएबल अंडर दिस एक्ट. सो हियर बी इज द करेक्ट आंसर. ये ट्रू हो ही नहीं सकता, पार्टली ट्रू भी नहीं. ओके, बट ओनली अप टू सर्टेन लिमिट ऐसा कुछ भी नहीं है, डिपेंड्स ऑन सर्कमस्टेंसेस नहीं है. He can deduct that. So here in this case B is the correct answer. Moving on to our next question. Which of the following statements is or are correct regarding the deduction of amounts from the bonus payable under section 18? section 17 में हमने देखा है कि अगर कुछ इंटरिम बोनस या फिर एडवांस बोनस कुछ पे किया तो ऑब्वियसली दैट कैन बी डिडक्टेड. और भी कुछ ऐसे डिडक्शंस कर सकते हैं क्या, वो इसमें देखेंगे. If an employee is found guilty of misconduct causing financial loss to the employer is allowed to deduct the amount of loss from the bonus payable to the employee in that accounting year, and this is very much true. Okay. Next, the employer can deduct the loss from the bonus in any subsequent accounting year if the misconduct occurred earlier. No, उसी accounting year में उनको करना पड़ेगा. So this is false. The employee is entitled to receive the balance of the bonus after the deduction of the loss caused by the misconduct. Yes, this is also true. जो भी loss हुआ है इसकी वजह से, employee की वजह से, that they have to deduct, rest they have to give it to the employee. So this is true. The deduction of loss is applicable to any amount of bonus payable under the act irrespective of the accounting year. No, ऐसा कुछ नहीं. जिस accounting year का उसी accounting year में close करना पड़ेगा, उसको कैरी फॉरवर्ड नहीं कर सकते उस तरह की चीजों को. सो दिस इज फॉल्स. सो ओनली 1 and 3 आर करेक्ट. सो हियर बी इज द करेक्ट आंसर. Moving on to our next question. Which of the following statements is or are correct regarding the time limit for the payment of bonus under section 19? Okay, so let's have a look at the statements given. If there is a dispute regarding payment of bonus pending before any authority, the employer must pay the bonus within 1 month from the date on which the award becomes enforceable. कुछ उन्होंने award मतलब इसमें क्या है, कुछ judgment दिया है, right? Enforceable or the settlement comes into operation within 1 month, that has to be done. This is very much true. Okay. In case other than a dispute, अगर कोई dispute नहीं है, then the employer must pay the bonus within 8 months from the closure of the accounting year. This is also very much true. Within 8 months they have to pay. अगर कोई dispute ऐसा कुछ भी नहीं है तो the appropriate government or an authority specified by it can extend the 8-month period for the payment of bonus provided the extension does not exceed a total of 2 years. Yes, this is also true. अगर कुछ circumstances से हुए हैं तो definitely they can, but not more than 2 years. So this is also very much true. The employer can unilaterally extend the payment period beyond 8 months without seeking approval from the appropriate government. Now see, यहाँ actually 1, 2, 3, 4 होना चाहिए. Now 3 and 4 completely contradictory. Either इनके हाथ में होगा या फिर appropriate government के हाथ में होगा, or any authority specified by the appropriate government, right? So when I am saying that the third statement is true, obviously this would not be true. So this, yes, this is false. So only 1, 2 and 3 are correct here under section 19. So here A is the correct answer, as you can see here. Moving on to our next question. The Payment of Bonus Act applies to establishments in the public sector. When is that happening? Or कब ऐसे होगा? When that would be applicable? That would be applicable when the establishment, the public sector establishment, generates at least 20% of its gross income from sales or services in competition with the private sector. Private sector में same industry अगर है, so अगर प्राइवेट सेक्टर के मुकाबले में ये एटलीस्ट 20% ऑफ इट्स जो भी ग्रॉस इनकम होगा वो सेल्स एंड सर्विसेज के थ्रू ही अर्न करेगा, देन दिस पेमेंट ऑफ बोनस एक्ट वुड बी अप्लाइड टू द एस्टैब्लिशमेंट, public sector establishment. So yes, in this case it is B that is the correct answer. Okay, so moving on to our next question. See here, which of the following statements is or are correct regarding the recovery of bonus due from an employer under section 21? अगर कुछ बोनस रह गया है एम्प्लॉयर के पास, किस तरह से वो रिकवर कर सकता है एम्प्लॉय? 1. If any money is due to an employee by way of bonus under the settlement, award or an agreement, अगर कुछ है, the employee or his authorized representative may apply to the appropriate government for the recovery of the money. Yes, this is very much true. वही सही process है. In case of employee's death, his assignee or heirs can apply for the recovery of the bonus due. This is also true as per the legal proceedings. The appropriate government will issue a certificate to the collector for the recovery of the bonus due, which will be recovered in the same manner as an arrear of land revenue. अगर land revenue pending है तो किस तरह के procedure follow करके वो दे लेंगे, उसी procedure को यहाँ पे वो करके employer से वो amount employee को दिलाएंगे. So this is also true. Every application for the recovery of bonus must be made within 2 years from the date of money that became due. Now within 1 year the employee has to follow the process that we have discussed. ये appropriate government के पास जाना, वो certificate देना, ये 1 year से पहले ही उसको appropriate government के पास जाना पड़ेगा कि ये due है employer से उनका bonus. So in this case 1, 2 and 3 statements are correct. So here C is the correct answer. Moving on to our next question. Under the Payment of Bonus Act, what is the obligation of every employer regarding the maintenance of records? Let's have a quick look at the statements. To prepare and maintain registers and records in a manner specified by the employer. No, this is not true. As per the prescribed format, they have to maintain. To submit all records and registers to the government authorities on a monthly basis, ये भी true नहीं है. Only उनको maintain करना पड़ेगा, ऐसा नहीं है कि उनको submit करना पड़ेगा. To maintain records only for a period of 1 year, no. To prepare and maintain registers, records and other documents in a form and manner prescribed under this act, जो भी प्रोसीजर है उसी के बेसिस पे उनको करना पड़ेगा, सो दैट वेन एवर इंस्पेक्टर कम्स वो उस रिकॉर्ड्स को सही से अगर कुछ चेक करना है तो दैट दे कैन चेक. Okay, so under section 26 the maintenance of registers and records says that every employer shall prepare and maintain registers, records and other documents in a form and manner that has been prescribed. So here in this case B is the correct answer. Moving on to our next question. Which of the following powers are vested in an inspector appointed under section 27 for the purpose of ensuring compliance with the provisions of the act? Okay, so here the inspector can require an employer to furnish any information deemed necessary for ascertaining compliance with that. Definitely they have to provide जो भी records है registers है कि हमने ये bonus pay कर दिया है, उनसे जो acknowledgement लिया वो ऐसे कुछ भी वो मांगता है तो definitely they have to provide that they are complying with the act. The inspector may enter any establishment or premises connect therewith at any reasonable time. सही टाइम पे आना चाहिए and require the person in charge to produce accounts, books, registers and documents related to employment, salary, wages or bonus. Yes, this is also true. Definitely they can look at. The inspector has authority to examine the employer, his agent, servant or any other person in charge of the establishment or any other person the inspector believes to have been employed there. Definitely he has every right to do so that सही से information उसको मिले. The inspector is not authorized to make copies or take extracts from the documents maintained in relation to the establishment. No, उनको ये right भी रहेगा कि अगर उनको कुछ copies लेना है ले जाके फिर उसको बाद में verify करवाना है या फिर कुछ करवाना तो definitely he can take as per the powers that have been vested with him. So this is false. So only 1, 2 and 3 are correct and here A is the correct answer here. Yes. Moving on to our next question, cognizance of offences under section 30. Who can take that? Okay, so under the Payment of Bonus Act, which of the following statements is correct regarding the cognizance of offences? Who can take that? No court shall take cognizance of any offence punishable under this act except on a complaint made by or under the authority of an appropriate government. Who is that person? If appropriate government, central government है, like in sectors like oil fields, mines, etc., regional labor commissioner only he can go for this. And अगर state government है, appropriate government like pharma, textiles, etc., उसमें labor commissioner. So here only a court of a presidency magistrate or a magistrate of first class can take cognizance of an offence punishable under this act on a complaint made by the appropriate government or an authorized officer. जो हमने देख लिया सेंट्रल गवर्नमेंट में कौन है, अगर स्टेट गवर्नमेंट का सेक्टर है तो कौन है. So here B is the correct answer in this case. So moving on to our next question. Which of the following statements is or are correct regarding the special provisions for payment of bonus linked with production or productivity under section 31A? So the first statement says employees are entitled to receive a bonus based on an agreement or settlement linked with production or productivity in lieu of a bonus based on profits under the act. Yes, this is true क्योंकि उनका जितना profits है based on that minimum bonus तो देना पड़ेगा. अगर नहीं हुआ तो उनको एक मैक्सिमम बोनस देना पड़ेगा. वो हमने देख लिया है in the earlier sections, right? So this is true. Any agreement or settlement that deprives employees of their right to receive the minimum bonus is valid and enforceable. No, क्योंकि मिनिमम बोनस उनको देना ही देना है. अगर किसी एग्रीमेंट में उन्होंने किया है कि नहीं अगर हमें ये प्रॉफिट बोनस नहीं मिलेगा ऐसा कुछ है तो that would become null and void under this act. Okay, so this is false. Third, employees are entitled to receive a bonus linked with production or productivity, but the bonus paid cannot exceed 20% of the salary or wage earned during the relevant account year. Yes, अगर excess में है तो हमने देखा है maximum bonus दे सकते. कितना होगा maximum? That is 20% of the salary or wages, right? उतना ही देना पड़ेगा. minimum है तो 8.33% और 100 रुपीज मिनिमम देना पड़ेगा. इवन दो वो एलिकेबल सरप्लस कुछ भी नहीं है, प्रॉफिट्स नहीं है, दैट वुड बी कैरिड फॉरवर्ड, राइट? सो हियर दिस इज ट्रू. सो ओनली 2 इज फॉल्स, 1 and 3 बोथ आर करेक्ट. ओनली 1 करेक्ट? नो, क्योंकि दूसरा भी करेक्ट है. ओनली 3 इज करेक्ट? नो, बोथ आर करेक्ट. सो 1 और 3 आर करेक्ट. सो हियर A is the correct answer. Moving on to our next question. Which of the following classes of employees are excluded from the provisions of this act under section 32? ओके जहाँ पे भी सोशल वेलफेयर इंस्टीट्यूशंस होंगे और लाइक योर आरबीआई इंडस्ट्रियल फाइनेंस कॉरपोरेशन ऑफ इंडिया और एनी फाइनेंशियल कॉरपोरेशन अंडर established under section 3 or any joint financial corporation established under the section 3A of the state financial corporations act etc insurance companies etc their वहाँ पे इनको प्रोविजंस के अंडर नहीं आएंगे लाइक एम्प्लॉयज एम्प्लॉयड बाय द लाइफ इंश्योरेंस कॉर्पोरेशन ऑफ इंडिया यस दिस इज ट्रू seamen yes this is also true employees employed by universities and other educational institutions established for profit no not established for profit जहाँ पे भी not for profit होगा definitely वहाँ पे this bonus payment of bonus act लागू नहीं होगा so this is false here employees employed by industrial development bank of India here this is true so here 1 2 and 4 are true 3 is not true. So here in this case, A is the correct answer. So moving on to our next question. Which of the following statements are correct, is or are correct regarding the applicability of the act to employees under section 32? मतलब act do not apply to certain classes of employees. इससे पहले जो हमने देखा था उसी के बेसिस पे है. The act does not apply to employees employed by any insurer carrying on general insurance business. This is true. That applies to employees employed by the Reserve Bank of India. No, this is not true. This is false. Employees employed by the Indian Red Cross Society are covered under the provisions of its act क्योंकि ये not profitable है so definitely ये इनका नहीं इसके ऊपर apply नहीं होगा so this is also false. Okay. That does not apply to employees employed by inland water transport establishment operating on routes passing through any other country. This is also true. Yes, it does not apply. So here in this case, only 1 and 4 are correct. So as you can see here, 1 true hai, this is false, and it does not apply to the, yes, this is true. So only 1 and 4 are correct. So B is the correct answer. Same जो हमने इससे पहले किया था, उसी के basis पे थोड़ा सा in different way they have asked the question. थोड़ा सा practice के लिए. Okay. So friends, अब तक आपने देखा है कि हमने किस तरह से कई तरह के एक्ट्स का हमने देखा है कि क्वेश्चंस हम लोग कंटेंट जो है वी आर डूइंग इन द फॉर्म ऑफ एमसीक्यूज एंड बहुत अच्छे तरीके से हम लोग प्रैक्टिस कर रहे हैं along with that EduTap has been currently offering 3 major courses associated with the upcoming UPSC EPFO 2025 examination for both APFC and EO or AO examination. Okay, so the first course itself is a master course मतलब इसमें A to Z आपको सब कुछ मिल जाएगा content PDFs, content videos, all the topics, all the subjects associated, everything, one point contact आपको है. Along with that every week इसमें कुलदीप सर एक strategy session लेंगे every Thursday to be precise and क्योंकि बहुत सारा कंटेंट है तो स्ट्रैटेजी भी बनानी पड़ती है कौन सा कंटेंट किस तरह से कैसे पढ़ना है कैसे यूटिलाइज करना है इस कंटेंट को वो सब वो उनमें समझाएंगे along with that आपके जो भी डाउट्स है वो सब वो क्लैरिफाई करेंगे. सो ये हो गया ऐसे स्टूडेंट्स के लिए जो बिल्कुल अभी प्रिपरेशन स्टार्ट कर रहे हैं एंड दे आर लुकिंग आउट फॉर नो कंटेंट एट वन ऑल एट वन प्लेस. दूसरा है टेस्ट सीरीज प्लस. ना ये ऐसे बच्चों के लिए यूजफुल रहेगा जहाँ पे कई बार ऐसा होता है ना कि हमारा ऑलरेडी कुछ आइडिया है कुछ सब्जेक्ट्स तो हम पढ़ लेंगे लेकिन कुछ सब्जेक्ट्स ऐसे हमने कभी पढ़ा नहीं है तो हमें लगता है बस ये एक दो सब्जेक्ट्स हमें एक जगह पे मिलेंगे तो बहुत ही बढ़िया होगा. तो उस तरह से बच्चों के लिए एंड अलॉन्ग विद दैट टेस्ट सीरीज ऑल्सो तो उनका एक प्रैक्टिस भी हो जाएगा. जो सब्जेक्ट्स उनके पास नहीं है वो भी कर सकते हैं. तो ये हो गया सेकंड कोर्स. थर्ड कोर्स है एक्सक्लूसिव टेस्ट सीरीज. सो इसमें क्या है जो बच्चे ऑलरेडी प्रिपेयर कर चुके या एक बार एग्जाम दे दिया है इससे पहले भी एंड स्टिल दे आर प्रिपेयरिंग वन मोर टाइम और कुछ बच्चे ऐसे होते हैं कि खुद से प्रिपेयर करते हैं सो उनके लिए लेकिन ऐसे बच्चे ढूंढते रहते हैं कि टेस्ट कुछ क्वेश्चंस हम लोग चैप्टर क्विजेस करें या फिर कुछ टेस्ट प्रैक्टिस क्वेश्चंस करें एंड गेट द रियल फील ऑफ द एग्जामिनेशन प्रायर टू द एग्जामिनेशन. ऐसे बच्चों के लिए बेस्ट कोर्स है. सो इफ यू हैव एनी डाउट्स यू कैन ऑलवेज रीच आउट टू एनी ऑफ द EduTap faculty or the people and you can get your doubts clarified related to these courses so that you can make an informed decision. Okay. Thank you very much for being with me so patiently till now. Thanks a lot. So see you all soon in with the next session. Till then, take care. Bye bye.